preponderance of evidence that the stated reason for the defendant's actions were a pretext for the alleged discrimination. We as the defense would like to prove that Kevin Murphy was acting in a non-discriminatory way, and the reaction of Miss Elise Roberts have been because she was too sensitive to the material. I would also like to bring up Newman versus the City of New York, intentional infliction of emotional distress, which the plaintiff will be arguing that Elise experienced, consists of extreme and outrageous conduct on the part of the defendant, which intentionally or recklessly causes the plaintiff severe emotional distress. Intent or recklessness can be inferred from the outrageousness of the acts. The defense would like to argue that Murphy's actions were not reckless. Thank you.
Very good. Before you call your first witness, make sure that you swear them in by grabbing the Bible over there, which is behind Hayden's head. Hayden, would you hand him the Bible?
This is?
Yeah. All right. Yeah. Very good. Please put your left hand on the Bible and raise your right hand when they call, just to remind you. Sorry, we're breaking a new bailiff today.
Yeah, my bad.
Very good. All right, so prosecution. Plaintiff. When they call a witness, you can ask.
Right, we would like to call Elise Roberts to the stand.
Yep. Okay.
Yes. Okay. Very good.
So you are an ADA, correct?
Yeah.
What bureau did you work for when you worked with Kevin Murphy, the defendant?
I worked for the Felony Trial Bureau.
How did you feel about earning that position at that bureau?
That was extremely exciting for me. A lot of attorneys work really hard to get to that bureau, and it's a goal for a lot of them. So that was a big deal, especially being one of only a few women who worked in that office.
When did the harassment start?
Basically immediately. When I first started working with Kevin, he initially just gave me a bad time and teased me and joked that he didn't want to share an office with me. But shortly afterwards, within a couple of weeks, I would say, he began making inappropriate comments towards me. He would touch my back and shoulders.
Objection. Narration.
Okay.
I'm going to allow this.
Okay. And made comments and did things that made me extremely uncomfortable. So.
How did this affect your work?
It made me really uncomfortable in my own workplace. I felt unsafe and didn't want to go to work, and that, I think, had a negative effect on my performance.
Okay. How did this affect your personal life?
I began experiencing extreme anxiety. My self-esteem dropped, and along with that and with anxiety, I had physical symptoms of that. I had difficulty eating and sleeping normally, and often felt nauseated.
I would like to present some evidence.
Okay. We approach the bench. Let the record show that what we're looking at is the plaintiff's employment record of her leave and vacation time, and we'll mark this as Exhibit A. Would you like to examine the employment record?
We have a copy already.
Okay. Very good. Would you admit this into evidence, Bailiff? Thank you.
So, how many days did you take off?
24, I believe.
And do you believe that this is because of, sorry, scratch that. Are you aware that the days that you do not take off, you get paid for at the end of the year?
Yes.
So why would you not take that opportunity?
I didn't feel comfortable in the workplace working with Kevin and didn't want to be there. I often had felt sick, I think, as a result of anxiety, and didn't feel well enough to come to work. So it wasn't worth it for me to put that off and to get paid.
Okay. How many times did you complain to your superiors?
Twice. Shortly after this all began, I went to Fran Troy, who spoke to Kevin, but nothing really changed. I'm still having the same problems with him. Later on, I think in January, I went to Fran Troy again and didn't feel like he was helpful, so I saw Sandy Yu, who made me aware that I could go to the EEOC, and I filed my complaint with them shortly after that.
What were the results of your performance evaluations?
Initially, my first review, I received a good rating, and they dropped from there. My second review was fair, and my third review was poor.
In your opinion, what do you think caused your evaluations to the results to go down?
Objection, opinion.
Yes, but in this case, her opinion is relevant because she's the actual employee that was being conducted, so we're going to go ahead and allow that question to be answered.
I'm sorry, can you repeat the question?
In your opinion, what was the cause of the results of your performance evaluations to go down?
Kevin's behavior took place.
When were you transferred to a different bureau?
I was transferred to the family.
Objection, leading the witness.
It seems like a straightforward question.
But that's assuming that she was transferred, and that's leading the witness.
Was
You
she
were
not
in fact transferred.
Yes.
No, this is part of the record of her employment record, so we'll go ahead and allow that.
I was transferred to the Family Offense and Complaint Bureau in January, shortly after my third evaluation.
What was the reputation of that bureau that you were transferred to?
It was really poor, especially in contrast with the Felony Trial Bureau where I had been working. The general sentiment is that our employers transfer people there to get them to quit, and it's a poor experience.
And I'm finished. I do not have any more questions for the witness.
She's now turning the witness over to the defense. Would they like to have a cross-examination there?
Yeah.
Do you want him to stand
So I'd
somewhere?
like to address
Do
the
you want him to stand
touching.
over there?
Okay.
Kevin did
in
in
the
fact
camera.
touch you, correct?
Yes.
Excuse me, one moment.
And
One
you
moment,
told him
hey,
to
what-
keep
sorry,
his.
excuse me.
Okay, sorry.
One moment.
Do you want him to stand over there so he's in the camera?
You can either move or you can have him go over there, that's fine. What would you
Whatever
prefer?
works. This needs to stay plugged in.
Okay, to stay plugged in. You don't have to get everything. But if you guys do get more comfortable, it is okay because this is being, closed circuit televised. So if you want to come over here a little better camera angle, but you don't, wherever you're most comfortable is fine. We've got the audio, which is all we need. Was there another question over there? I'm sorry.
I have a question.
Yeah.
Can I tear the piece of evidence off my packet so I can still use my?
Absolutely. Yeah, absolutely. Sorry about that,
Okay.
Counselor. We'll let you readdress from where you began.
From the beginning?
From the beginning, please.
Okay. So is it true that Kevin touched you?
Yes.
And you told him to, would you please keep your hands off me, correct?
Yes.
And did Kevin keep his hands off you after that?
Not that I recall. I remember that he still would touch my shoulders and back occasionally.
In your affidavit, it says that he never, after you told him to keep his hands off of you, he stopped. He never did it again.
Oh, okay, that's my mistake.
Okay, so when you went to Troy after that event,
Yes.
and did Troy talk to Kevin?
Yes.
And so did Troy fulfill his responsibilities as the lead of the department?
I don't think so because the problem continued. Not necessarily the touching, but he's continued making comments to me after that fact.
So, I'd like to address the attendance record that they brought up. You were sick a lot, correct?
Yes.
Even before you transferred to this bureau, I mean to the trial bureau.
Yeah, occasionally. But I would say that during my period working in that bureau with Kevin, it was a result of anxiety caused by the harassment.
So, before you took 6 days, it looks like, when you were in the bureau of misdemeanors and intake, you took 6 sick days. And then after transferring, the first half year you took 4 sick days, and then the other half year you were in the felony trial, you took 7 sick days. And so you said to the plaintiff that Kevin made you feel sick, correct?
Yeah.
And that he caused you to have more leave of
Objection, leading
absence.
the witness.
Strike that from the record that I agree that you were leading the question. Be careful with your questions. Do you want to
Okay.
restate that?
Which one?
The last point about the how she felt?
What do you mean, how she felt?
Well, you were asking her, could you ask the last question again?
The last question?
Yes, please.
That,
Try to ask
you mean
it.
the last one I asked, or
Yes,
the one I was about
the
to?
one prior to that.
That Kevin made her feel sick?
Yes. Would you restate that instead of leading her, would you ask her in a yes/no way that she can answer it yes or no? Did he make her feel sick?
Yeah, did he make her feel sick?
Yes, because of anxiety.
Okay, but you have up to 6 days, 10 sick days, correct?
Yeah.
So why did you not take more sick days instead of use her vacation days to leave work?
Well, I did, I'm sorry, what's the question?
Restate the question.
Restate.
Why did she use sick days rather than vacation days?
Why did she use vacation days rather than sick
Why
days?
did you use vacation days rather than sick days?
In case I was sick again.
Okay, and the defense rest.
Okay. You may step down.
All right. Detective Puma, so you've been working with the, the district attorney as a detective for the recent years, correct?
Yes.
And, and have you witnessed any of these said situations that, where between Kevin and Elise?
Yes, I have.
How have these situations made you feel personally?
Well, some of the comments that Kevin would make sometimes would make me feel embarrassed and offended.
Did you ever talk to Kevin about these encounters?
Yeah, I told him that he shouldn't treat his coworkers like that, and he replied by saying I used the term coworkers loosely because Elise hardly did any work.
And how did you take that?
It was a little strange that he would say something like that because I've worked with Elise in recent years and I know she's a hard worker.
And what was the atmosphere like in Kevin and Elise's office?
Really uncomfortable. As soon as I walked in, I knew that there was something weird going on, and if Elise would ask Kevin, if Elise would ask Kevin a question, he'd sometimes just ignore it like she wasn't even there.
All right, you turn the witness over to the defense.
So, in your affidavit, it states that you've worked with both Kevin Murphy and Elise Roberts, correct?
That's correct.
Okay. You also stated that when having meetings with Elise, sometimes she wouldn't be there to attend,
Right.
correct? Okay. How frequent would you say that would, or,
We'd have to reschedule appointments quite a bit. Yeah.
When working with Kevin Murphy, did he seem as serious as Elise Roberts?
No, I saw him as more of a funny kind of humor kind of guy.
All right, and you said that the humor offended you. Did you ever see it offend anyone else in the office?
No, he usually did it more around the lease, so a lot of people weren't around to hear it.
Okay. In the report, you stated that it was okay when it was just you and a coworker, but around other people that would offend the person that you are joking around. Does that make sense?
Yeah.
Would you say that's still true now?
Yes.
Okay. You said that occasionally Kevin's joking was humorous to you, correct?
Yes.
It was not always offensive?
No, but I can understand why some people could find that offensive.
And then, also in the affidavit, you said at one point that you may have thought Miss Roberts was overreacting, correct?
Yes,
The defense rests?
Further questions? Redirect?
No, Your Honor.
Okay, can you step down?
Yes.
Well, Dr. Isaacs, you are a psychologist, correct?
Yes.
Could you give us some background on your expertise?
I have an MBA in industrial psychology and a PhD in psychology, and I got those degrees from Georgetown University. I am executive director of the Working Women's Research Center in Washington, D.C. I have previously sat in 50 cases that involve harassment in the work environment, and my minimum fee is $1,700, which is because of my expertise that I have.
So you've had a lot of experience with cases just like this one, correct? What does your research mainly focus on?
My research involves work-related stress, basically, and it comes down to two different types of harassments. You have the quid pro quo harassment, which is when the victim is required to do tasks to keep her job, him or her to continue working, or there is the hostile environment where the victim is felt to be unwelcome within sexual conduct or more than one.
And what does it require for a situation to reach the level of sexual harassment?
It's unwanted conduct that is served to create an abusive work environment, which could cause stress, stress, anger, fear, and just poor quality for work.
Are there other medical symptoms that could come from this stress that they experience?
Yes. She could feel powerless, have low self-esteem, they can have headaches, they can have backaches, weight
Objection, Your
loss.
Honor. It's irrelevant evidence almost. It's not quite anything that we could take for being 100% true.
I think he's asking in general if a person were to be sexually harassed, what their condition might be like, right? So is this, you're not directly asking
No, we're
about
not
this
saying, we're not
particular-
asking specifically about Elise, but possible symptoms that could occur.
We'll allow it in that case.
And that's about it.
All right, and in this situation, based off of your research and the studies, do you believe that Elise was a victim of sexual harassment?
I actually think that she was, in my opinion, she was sexually harassed because when you look at it, you can't look at
Objection.
Mm-hmm.
He's just asking the witness to give an opinion.
Yeah, and on direct examination, it's not allowed. Did you actually have an opportunity to examine Elise?
Yes, I did. I had a 2 to 4 hour interview with Elise.
Okay, in this case, because they actually did have an interview together, it's not his opinion. even though he phrased the question that way, it's about their actual interview. And so because he's a professional with expertise, it's not just irrelevant in this case, and he has met with her, so we'll go ahead and allow it. Thank you. Please be careful about how you ask those questions. The defense is right to call attention to an opinion question. When he was not an opinion because they had actually an interview together. Yeah, you could rephrase the question, please.
Dr. Isaacs, in this situation, was Elise a victim of sexual harassment?
Yes.
All right. Thank you. We'll turn it to the witness over to the defense.
Yeah. You may cross.
So, could you read this? This is yours, correct? The statement? Could you read me this first sentence on this paragraph where it says my research? Oh, okay.
My research involves those who have been business-related stress problems, many of which include sexual harassment and discrimination towards women in the workplace.
So you've only been working with women, correct?
Yes.
So would it be okay for me to say that you haven't worked with any men in this situation?
Yes.
Okay. You're a psychologist, and you have a strong background. You have a PhD and everything.
Yep.
Is there any way that even with your PhD and all this, you could prove that she was sexually harassed?
Objection, Your Honor. This was already asked and answered in the earlier question.
It was, and the question was asked and answered. He already gave his professional opinion, which, because he is a psychologist, is admissible. So we'll move from that.
Okay.
Let me strike.
Fence rest.
Okay. Is there any cross?
Okay, Mr. Murphy.
Order in the court. You may begin.
Mr. Murphy, you like to joke around the office a lot, right?
That's correct.
And you joked around with multiple people. It was not just exclusive to Elise.
Right.
And some of these jokes, while they may be were not intentional to harm or harass anybody, correct? I would like to bring up the Sports Illustrated issue.
Right.
You got that into the office and showed it to a bunch of guys, correct?
Yes.
And you even hung up a picture of Elise, of a swimsuit with Elise under it?
That was a joke, but that is correct.
Correct, and it was nothing more than an L joke.
Nothing more than a joke.
Okay. And how did Elise seem around the office to you?
Well, in a way, I would say almost lazy. She didn't work as hard as she should have. She left early every day. She took a lot of days off. In a way, she didn't seem fully committed to her work and her career.
And was Elise sick a lot?
Yes.
And did you have to fill in for the work when she was gone?
That is true. I actually had to stay late many times in order to fill in for the work that she was missing.
And I would like to address what Elise called the date.
Right.
It was an invite, correct? Not a date?
So a lot of the people that we work with in our office, we like to go out to eat on Fridays. And I thought, to be kind and to include everybody, that I would invite Elise as well. This wasn't a date. This was nothing more than just to hang out with everybody else in the office.
And the defense will turn the witness over to the plaintiff.
Mr. Murphy. Would you say that you and Elise were friends?
Yes.
Is it true that in your in your testimony, you said she has no sense of humor, close quote, and that Elise is a poor trial attorney?
Yes, because of her poor work ethic.
But you two were still friends?
In a way, but you have to be friends with everybody.
So you were friends with her because you had to be?
Yes.
You also said that you teased her often. Is that true?
Correct.
And that this created a sort of joking atmosphere?
Yes, in a way that, remains with everybody. It's not
Did this ever seem to make Elise uncomfortable, this joking atmosphere?
Not that I was fully aware of.
Can you read a passage for me? It is from a previous case. It is the U.S. Equal Opportunity Commission Regulation number 802, starting at sexual harassment, please.
Sexual harassment means unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature when such conduct has the purpose or effect of unreasonably interfering with an individual's work performance or creating an intimidating, hostile, or offensive working environment.
And you never saw that this joking atmosphere could have created a hostile environment for Elise? You never saw that?
I never saw that.
Okay. In your statement, you also said that you stayed very late at work sometimes, usually leaving around 7, is that correct?
Yeah, I'd say about 7, never really.
What time did Elise usually leave work?
4:45 every day.
Why do you think she left work early?
Her
Objection,
poor work
opinion, lack of personal knowledge.
We're going to strike that from the record. You could try and ask a different way, perhaps.
Do you think Elise left work early because of the hostile environment at work?
Objection, leading the witness.
Is there another way that you could state this? Is there any personal knowledge that you have of why she left work, perhaps? Could you ask it that way?
Your Honor, you can't lead the witness on cross-examination.
I would like to remind the defense that they also objected I would remind the plaintiff that they also objected leading the witness during a cross-examination.
Right, so we have a couple of things going on now. So I understand that we're in kind of an area where it's a little bit sensitive because you were actually present. I want to give him some berth in terms of but you're going to have to ask it in a way that's admissible. And so the opinion question is one that you're correct on, but in this case, he did work there. So you guys were in a fine line here in terms of what he saw and what he observed. But he has to ask it in a way of what he actually observed and what he actually heard. So that's where we're kind of having an issue in terms of protocol. So it's a little bit in the way that the questions are being asked, but the actual content is not objectionable. So if you could ask it in a way of what he actually personally observed or was told, as opposed to the opinion given, that would be better protocol here.
Did Elise seem happy when she left work early every day?
No.
Okay.
Objection.
Okay, let's move on from this.
Okay. So you did Elise's, as Elise, you stated she was a poor trial attorney. Did that ever frustrate you?
Yes, in the way that it kept me from coming home at the time that I would like to.
Did you ever report your frustrations to Chief Francis Troy?
Good question. I think I did.
Can you tell us a little bit about that?
Yeah, he didn't do much about it.
Interesting. You didn't include that in your statement.
That is true.
Lastly, you said that you guys went to, I'd like to address the lunch situation one time. Do you recall? Second page of your testimony.
Yeah.
She didn't pay the exact cost of her sandwich, I made up the difference. You then said that she wouldn't be a party to attorneys having a drink at the lunch hour. Is this correct?
Yes.
So during your lunch hour, you and your attorneys would have a drink?
Objection irrelevant.
No, I think I'm gonna go ahead and allow that. One more time, would you restate the question?
During lunch, you and some of the other attorneys would have a drink.
Yes.
Did you ever have more than one drink?
No.
Regardless, though, you would come back to work after lunch with alcohol in your system?
Yes, a small.
Thank you.
Redirect? Any further questions?
No, I think we're okay.
You may sit down.
Elise Roberts went to you with a complaint, correct?
Yeah.
And then you were also in charge of attendance.
Mhm.
And Elise had a lot of sick days,
Yeah.
or days off. All right.
Counselor, it might be helpful if you ask her job, her name, and what she does for this work that
okay,
everybody
so-
may not know, and also if you could both speak up just a little bit louder.
All right. Well, yeah. Could you tell us your name and your occupation at the firm?
Yeah, my name's Sandy Yu, and I'm the personal director of the district attorney's office.
And what do you do?
My office keeps the records of attendance, sick days, and vacation days, and applications for employment, insurance forms, and other official documents for the district attorney.
Thank you.
Going back to the attendance record of Elise Roberts, it said that she could file for disability if she needed it, correct?
Yes.
And she didn't?
No.
So after not having success with you, she went to the EEOC, correct?
Yeah.
All right. Could you tell us the result of that?
Yeah, the EEOC report did not find in her favor.
Oh. In the affidavit, it also stated that 7 other women were interviewed by the EEOC.
Mhm.
Could you tell us the results of that?
Yeah, the woman in the bureau told the investigator that while Kevin made funny comments and joked a lot, they never felt sexually harassed by him.
Okay. Referring to the transfer to the Family Offense Complaint Bureau, the pay was exactly the same, correct?
Mhm.
And in your testimony, you stated that it was just rumors that this was where counselors were transferred to get them to go.
Could you please answer yes or no?
Yes.
So we're clear about what the answers are.
The defense rests.
Is there a class?
Okay. This is Sandy. In your testimony, you stated that Elise was very businesslike, correct? Very professional?
Yes.
Objection irrelevant.
No, it's part of her record as the HR and personnel director to give an opinion about how she found the
Objection beyond the scope then.
I think we'll allow this, but thank you.
Thank you. The defense attorney stated that she did not file for a short-term disability. However, short-term disability requires a doctor's note saying that the prosecution has to have physical ailments resulting from stress and need of stress. Did you see any physical ailments present in Elise?
Objection. Could he rephrase the question?
I think he's asking whether or not she observed her condition, and so since she personally observed it, I'll go ahead and allow that.
You didn't?
Besides that, she didn't come to work.
However, does short-term disability provide for mental ailments?
No, I don't know. No. Yes?
I can't.
No.
I'm sorry, could you please clearly state what you want to answer there? Yes, no, maybe?
Doesn't say anything.
It does not.
So, I don't know. How would I know?
It's okay.
Um,
Just for the record, her answer is that she doesn't know.
Elise came in on January 5th, 1989, correct?
Yeah.
And what did she want to do?
On January 5th,
15th?
15th. Oh, she wanted to, fill out a sexual harassment complaint form.
And did you give Elise a sexual harassment complaint form?
No. I told her to sleep on it and take a little more time, but if she came back in,
But you didn't give her the form, have you?
no.
Okay. Thank you. Finally, you stated that when someone is transferred to the Family Offense and Complaint Bureau, this bureau has a reputation for, quote, attorneys who are sent there aren't very good trial attorneys or when the office wants them to quit, close quote. Do you think that the bureau wanted Elise to quit?
No.
Objection?
Black personal
They're asking for the opinion.
Okay, yeah, we'll strike that. Do you want to ask a different question?
You stand behind your statement that attorneys who are sent here are sent there when the office wants them to quit.
Says that's the reputation, just to say that's.
Do you stand behind your statement?
Yes.
Okay, thank you, that's.
That's very good. Nice job. And also nice job for you, Taylor. That was a good redirect on that question. Because it's part of the earlier record, it would be admissible. And
What you do? Yeah, so I'm basically a supervisor of over 20 assistant district attorneys. And I don't know, basically I just manage people and I check all the files and organize everything and whatnot. So you could say that you see a lot of people in the office every day. Yeah. And you get to observe a lot of their job and all that. Okay. So whenever you recall having Kevin and Elise both come to you about this issue, correct? Mm-hmm. And when Kevin came to you, in any way, shape, or form, did he seem to be intentionally trying to harm Elise in any way?
No, didn't seem intimidating to her in any way. Just cool guy, really, as he always is.
Okay. When Elise came up to you, she was kind of distressed, correct?
Yeah.
Did Kevin give her any reason to feel that way?
I think nothing really
Objection, opinion.
could you restate the question?
From the actions that Kevin has had towards Elise, is there a reason for Elise to be feeling the way she is?
I think she is a little sensitive.
One second. In this particular instance where he was directly involved and it's his opinion that we're talking about as opposed to opinion of something that he was not directly able to form an opinion, we're going to go ahead and allow it. But you have a very narrow berth on this, so be careful. And let's make sure that we can stick to the facts.
All right, so I think nothing too serious to the point. I think she's a little sensitive on the things she's complaining about. I wouldn't say there's anything too far-fetched at all, really, from what I can tell.
Okay. That's all. Defense reps. Cool.
Do we have a cross?
Yeah. All right, Mr. Troy.
What's up?
So, you and Sandy have been working together for at least 3
Your Honor?
years, correct?
Yes.
I would like to be able to see my witness.
Could you maybe back up, please? No, fair enough, yeah.
So you and Sandy, you've been working together for 3 years, correct?
Yeah.
Were you aware, and it says in your statement that she skipped the standard appeal through Sandy, you went straight to the EEOC? Were you aware that when she visited Sandy, she was dissuaded not to fill out a form?
Leading the witness.
It's cross-examination.
I would like to once again remind the defense and the plaintiff that this same objection has been used on our cross-examinations and Mrs. Sands.
Asked and answered, is that what you're going for?
No.
You're,
Leading
okay,
the witness.
yes, in this particular case, I don't think he's leaving I'm gonna deny that. You may continue.
Were you aware of that?
Just repeat the question.
Were you aware that when Elise went to Miss Sandy Yu, she was dissuaded not to fill out a form of a complaint form?
I wasn't aware. Was I aware? Yes.
You were aware then, but you also said that she skipped that step in your statement.
I don't
So-
know what to say about that one.
All right?
So is that a no answer, to be clear?
Let's go with no, yeah.
You don't recall?
I don't recall.
Let the record show that the witness doesn't recall.
Okay, my next question is that, so in your statement you also said that Kevin has a crass sense of humor that at times needs to be tolerated, right?
Yeah, I mean, no, in a way, he says some funny things. He always gets everyone else around, but.
Can we please
there's
get a yes or
nothing-
no answer from the witness?
Oh, is it just yes or no?
So I'll repeat the question. You said that he sometimes has a crass sense of humor that needs to be tolerated, correct?
Yeah.
Okay. And so have you ever observed, and then you also went on to say that Elise and Kevin are two very different people, correct?
Yes.
Okay. Have you ever seen Kevin change his sense of humor to accommodate for people so different, as you put it, as Kevin and Elise?
No, he's funny around everyone, so no.
He acts the same around everybody? Okay. So I would also like to bring up the evidence brought about during the first part of the trial, the attendance of work. So after you transferred Elise, so before you noticed she had 24 absences, right?
Yeah.
And after, were you aware that she only had 4 in the same amount of time after her transfer when she was removed from Kevin's office?
Yeah.
You knew that so after she did have much less absences, all right? So my final question was that were you aware that when Elise walked into her own office at one point, she found Kevin in her underwear?
Objection beyond the scope of direct examination.
It wasn't brought up in the examination, so we're going to strike that. So jurors, please strike that from the record. That was brought up earlier, so that is not relevant. He's correct.
All right, I'm done.
Cool.
Okay, you may step down. Are there any other witnesses for the defense?
The defense rests.
Okay. At this point, we would like to hear closing arguments. So it's customary that the prosecution go ahead and give us their closing arguments.
Okay. The defendant, Kevin Murphy, is guilty, and he did sexually harass...
Excuse me, could you please state your name for the court?
Oh, sorry. I'm Jackson Gardner. I am with the prosecution. Okay. The defendant, Kevin Murphy, is guilty, and he did sexually harass my client, Elise. He discriminated against her because of her gender, and he created an intimidating, hostile, and offensive work environment. A precedent, Fisher v. Washington, ruled that to prove sexual harassment, instances must occur, and several instances did occur. Kevin would return from his office from lunch with alcohol in his system. He touched Elise in uncomfortable ways. Kevin would often change in their shared office, even after Elise asked him to stop. This caused Elise to feel ill and prevented her from coming to work. He made sexual comments around the office, like, quote, will we get to see you in a swimsuit? I want to see what you look like without your suit on.
"Why are you leaving so soon? You got a hot date tonight." He would mock her by writing her name on photographs of women in swimsuits and make sure that others notice. This caused her to lose all confidence in herself. And she was so emotionally upset that she went to counseling. Elise began to feel like there was nothing she could look forward to, and eventually, after continuously being sexually harassed, Elise received a poor review and was demoted. The district attorney's office says that sexual harassment in any form will not be tolerated, yet Kevin's sexual jokes were continuously tolerated, and this is wrong. The defendant, Kevin Murphy, is a bully and guilty of ruining Elise's confidence and eventually her career, which is why we are asking for $260,000. Everyone has been bullied in their life, and I ask you, jurors, to put yourself in Elise's shoes and imagine how you would have felt in this situation. The defendant must be punished so we can learn his lesson and we can prevent sexual harassment in the future. That's all, Your Honor.
Thank you. When we have finished hearing closing arguments from the defendants, I'd ask that the jurors elect the foreman, if they haven't already done so, and convene in room G102, and please deliberate, and as quickly, expediently as you guys can, take a vote and let us know how you rule in favor of the plaintiff or in favor of the defense, and if there are any recommendations in terms of penalties. But before you do that and you're recessed, I would like to hear closing arguments from the defense.
I am Nicholas Hunter. I am assisting the defense.
Nicholas, you've been in my court many times. Do you really feel like this is appropriate attire for the court?
What do you mean? The plaintiff was required to prove with a preponderance of evidence that emotional distress occurred with the reasonable victim standard both sides have adopted, and should the defense bring up a non-discriminatory reason for the defendant's actions, the plaintiff would have to prove, under the same standard of preponderance of evidence, that reason was in fact covered for the actual discriminatory reason. Every opportunity the plaintiff's counsel had to reject the notion that the plaintiff was not a reasonable victim was ignored. In fact, Mr. Puma, one of the plaintiff's witnesses, has stated that she was overreacting, nor did the plaintiff attack the idea that the defendant was merely teasing the plaintiff as an act of camaraderie. Precedent states that the plaintiff must prove the sexual harassment, which requires emotional distress, occurred on the reasonable victim standard. They didn't prove Elise's status as a reasonable victim. Puma said contrary in fact. The plaintiff had to prove the acts were done as a discriminatory action based on said. They didn't even address the teasing more than acknowledge its possibility of existing. Everyone involved on the side of DC that Elise refers to as not doing their job, they really did their job. Her sick days were consistent. Her transfer was merely that, a transfer. The EEOC, a government agency that looked into this matter thoroughly, said that Elise didn't have enough evidence for sexual harassment. Another thing to add, didn't change, therefore no discrimination. Unlike the plaintiff, our evidence didn't need to be brought up in closing arguments, and that's all I have.
Okay, at this point, the defense has rested.
And this is because the EEOC did not have enough sufficient evidence to support the plaintiff's claims, and all the other witnesses seem to have the majority claim that he had innocent jokes and Elise Roberts was exaggerating in this scenario.
Thank you all for your service. May I see the verdict, please? May I see the verdict, please? Thank you, jurors, for your, yes, please bring it up. Jurors, you guys, it's okay, I didn't see it anyway. Jurors, you guys did a great job. Thank you for your, cooperation and participation. Order in the court. This will conclude.